you, Mega. I'm so happy to be here. Good morning, good evening, good afternoon, depending on wherever you are in the world. But I'm so honored to have Priya, Brad, Harshita, Vaibhav on this panel. As you may know, that we've been doing a lot of client continuing education seminars, webinars. In the last 2 months, we have done over 130 webinars on various topics, all kinds of topics, with some aspect of legal relevance to those topics, and even some cases, interesting topics like can we move Parliament to the cloud? You are welcome to look at the recordings of those, and we still have a lot of other webinars planned up for this week, next week, week after. So hope you can join us. So before we start, I would like Mr. Nishith Desai, the founder and managing partner of the firm, to give welcome remarks. He has been in this space for over 40 plus years, and he has seen everything, many ups and downs in this area. So I would invite Mr. Nishith Desai to welcome remarks.
Thank you so much, Mihir, for your wonderful introduction. I'm excited to be here and welcoming, Priya and Brad and Vaibhav and Ashita and, everybody around. So I think it's been very good. I went for flipping of companies, right, from India to the US. I distinctly remember there was a wave of inversion in the US. There was a time in 90s when US companies wanted to move out of the US and come to India. Companies, and in fact, we worked on for it used to be called inversion. So inversion was a very popular way of structuring, and we were involved in the very early ones and structured a lot. And because at that point of time, US had, of course, very high tax rates, and if you flip to India and become Indian company, special economic zones provided you with special tax exemptions. So if you move your headquarters to India, then you're you know you're not taxed on that income on a worldwide basis. Only income arising in the US were taxed, and some of the other advantages. So many US companies had gone in for inversions. Now US tax rates have come down, plus other and the valuations are better available in the US. So there is now some kind of I would say wave at that point to consider going to the US. But like any other situation, these are complex transactions, number of issues, not only tax, exchange control, and corporate law, and other ones do come into picture. And transfer pricing, in particular, of intangibles is becoming very interesting and important part of the game. And with general anti-avoidance, it's all the more important how do you structure. New concepts have been introduced about what we call a place of effective management and all those kind of things that have come into Indian context. I think we have to take care of all of them. And at the end of the day, you want to make sure that whatever you do is not only apparently right, but also is substantially correct. And it's an art, structuring. It's an art to flip a company. It is just not a hard science. And therefore, it is very important to make sure that, all the nuts and bolts are in place, the proper documentation is done. And this the most important part of any structuring, particularly cross-border, it lies in documentation. It's no longer going on a whiteboard and drawing something and then, okay, it's great thing done. How do you translate a structure which you draw on a whiteboard and into a properly written document? That is where the art lies. Because an
Absolutely.
advice I would give to everybody, I think, and that is that whenever you have any document done, focus on recital. Recital gives you the background why this thing you are doing or why this documentation you're doing for what reason. So bring out a story that it is not necessarily and only meant for tax avoidance. You know, very important how you write the recital and articulation of that is legal and put all the kind of thing around the place. So I would not go too deep into this at this point in time because you are all good experts, but it's very interesting to look at this flipping of the company, and just like human beings migrate from one place to other, even corporates also can migrate from one place to other. you know.
So true, Nishith bhai. No, I think this is great start because you identified a lot of issues which are very relevant, and we are going to cover most of them or all of them in this session. So really looking forward to that. At some point of time in life, whenever you have a startup, especially startup with the global market in the mind or US market in the mind, at some point of time you have to think about it. What do I do with this startup? In terms of structuring? Should I continue to stay in India? Should I move to Singapore? Should I move to US or whatever? So that part or that aspect of going external uh, is becoming an issue because you are always used to your local jurisdiction and you don't know what's going on in other jurisdiction. What are the other benefits or advantages or disadvantages of that? So we have this great panel today coming together, and I want to thank also Silicon Valley Bank for being a co-host on this panel. So thank you, Priya. Thank you, Brad, for joining from Gunderson, and my colleague Harshita. She is in India. She heads our startup practice, so it's great to hear her views. So we have people from different areas, and Vaibhav, who has also been in this space for over 2.5 decades. And he heads now our New York office and deals with this kind of situation day in and day out. So I really look forward to having all these panelists. And let's start with Priya. What is flipping, and what are some of the reasons why companies think about flipping?
Yeah, and first of all, I want to say thank you for this opportunity and looking forward to this exciting discussion. Just a way of introduction, I'm Priya Rajan, Managing Director at the Global Gateway for Silicon Valley Bank. So I'm also the market lead for India. I work with companies and funds coming out of India looking into the US market. So this concept of conversation about flip comes all the time. So typically the companies that we work with are the companies that starts off with US as a subsidiary, because that's they're very early on in their process. Over time is when the conversation about flip comes. And what does that flip mean? Flip is typically a US flip means a transaction is a process of creating a US holding company for an international company, in this case, an Indian subsidiary. So how does it look post the flip in a very simple sense? Because you have experts here to talk about more on what that means. Is now the Indian company would be owned by the US company. Why? Why would a company even think about doing this? At least from my view, right? Where have I seen many of these cases happen? It's usually a business reason. It's usually a market reason why a company would look at a flip, right? Few different things. I just noted it down, like few questions I'll ask for a founder, like have them think through, and obviously work with your investors or angel investors to think it through, right? Because especially if you're a first time founder, are you looking into US for raising venture capital? And is your path of the business a venture capital business? Then it's a yes, right? Do you have a global business, meaning the sale of your products, is it to a US company, or is it to a non-US company? So I think that you need to kind of map it out to see where your market mapping of the sales is, right? I know when you pitch to investors, we tell them not to put the exit strategy in your deck. But in this case, you want to think about exit strategy. Yes, you want to think about long term. What is your exit strategy? Are you thinking about like IPOs, right? If the IPO is in US markets, again, you have experts here to talk about kind of the tax benefits or the tax flexibility that that structure offers. So that's something to consider. Last but not the least, I mean, I think it goes along with the exit strategy, but are you looking for acquisition, right? If you're looking for acquisition into a kind of a US entity, then that structure might make more sense. I've also seen where, with all of these considerations, teams start moving their founding teams over to US, right? That's a good stage for you to consider. If you have a significant portion of your team members starting to be based out of US, then maybe you are, you don't want to get too late, which Vaibhav and Bradley would talk about a little bit, right? So I think these are some things that I would think about that folks need to consider while they're thinking about a flip. But obviously, we're looking into more detail to talk about it.
No, that's great, Priya. Harshita, would you like to add something from what you have seen from the Indian companies?
Yeah, thanks, Mihir. And I think just to add on a little, some few pointers to what Priya mentioned and what I have seen from my experience in dealing with startups who flipped to the US or looking to flip. I think, unlike a few years back when companies were actively looking to flip primarily for tax reasons, that isn't the case anymore. So although tax may be one of the reasons to ensure that there are no adverse tax consequences more so for the US entity, there are a couple of other reasons that have, that have recently come up in my discussion with the startups. One is a lot of these accelerator programs which are run in the US, which is by institutions like Y Combinator or 500 startups, they generally only accept US companies, which is entities which are incorporated in the US, in order to become eligible for enrolling into such programs. So that becomes, a little aspirational for a lot of Indian promoters, and which is why we see Indian companies setting up a holdco through appropriate structuring methods so that they can avail the benefits of the of these accelerator programs. The second, I think, just on Priya's point on access to venture capital, I think there's also a lot of ease of capital when it comes to raising it abroad, because even now investors feel a little more comfortable investing in other jurisdictions. In terms of to give you examples, in terms of signing standard form documents as compared to documents which are heavily regulated by Indian laws here, or flexibility to bring in debt in other jurisdictions. Unlike India, where foreign debt investments are still regulated in terms of eligibility norms, end use restrictions, etc. So I think, and just these 2 points apart from the commercial and the exit reasons that Priya mentioned.
Brett, anything else you have seen other than what Priya and Harshita has mentioned? Brett and Vaibhav, either of you?
Yeah, I think what I've also seen is later stage companies that are looking to, I think it was mentioned by Nishith Desai, to access the capital markets in the US or elsewhere, that look to make that move later in their life cycle. I think there are a lot of additional considerations to take into account, and much more complexity with US securities laws, tax on the Indian side and US side, and a lot of planning and structure is required for those companies, but that's also, I've seen that happening as well in the last few years.
No, so there are many reasons, right? There are market reason, access to market, access to technology, access to funds, access to other kind of financing, tax, legal. There are many issues that goes into thinking about whether to flip or not. So I come to Vaibhav and say, I'm an Indian company. Should I flip or not? I have to think about go, no-go decision here. So what is your perspective on this?
Yeah.
And what do you advise?
Thank you, Mihir. See, I agree with all the previous panelists who talked about business reason. And I think that's the first key thing. Is there a business case for me to flip, right? So once you decide that there's a business case for me to flip from operation and business perspective, then you need to look, can I flip? Is it possible for me to flip? And if I can flip, what is the cost of flipping, right? And then you take a decision saying that the risk of flipping or the cost of flipping, does it meet the reward which I will get once I flip, right? So that's the decision you take. In addition to what the panelists mentioned, I just want to point out a couple of points here from Indian law perspective. One is that when you are taking a decision to flip or not flip, Priya mentioned about IPO, right? And one of the exit considerations IPO, and then you want to see where you want to do an IPO, right? Often we need to keep in mind that if you are an Indian company, right? If you're a US company, you can't go public in India unless you do an IDR, which only one company has done till now, to my knowledge. If you are an Indian company and you're an Indian private company, you may not be able to go and list yourself in US stock exchange until you have listed in Indian stock exchange. Of course, I know things are going to change now, and they're already in process of changing. Some announcement has made, so hopefully that will change, and Indian companies can go public outside India. Indian private companies going to go public outside India, but we don't know in what shape that will pan out. So knowing IPO, where you want to go IPO, is an important consideration. And I know for a fact that a couple of companies which became large companies flipped because they wanted to access US capital market, because they didn't believe they can get a decent premium in Indian market from debt perspective. Secondly, you need to look at it from cost perspective, right? Early stage, it is easier for you to flip. The cost of flipping is less. The risk of flipping is less. As company starts building, the cost of flipping starts increasing. And when I say cost, I mean the cost from tax perspective, cost from perspective of risk which you build up on exchange control side, perspective of the effort which you need to put to get the current shareholders who are shareholding an Indian company to move to US, for example, and the cost which incurs from their perspective, right? So there are a lot of reasons we prefer to get flipped at a very early stage rather than late stage, because as company starts maturing, it starts growing, it becomes more and more difficult for you to flip. Now there is some situation you may not be in a position to flip because it may end up violating Indian laws. So even though it may be a good business case, it may be difficult for you to flip, right? So
can you give an example, Vaibhav, there? Just
example is, for example, let's say a lot of your current investors are from India, right? Let's say you have got 50, 100 angel investors from India, right? Now to flip them to the US and then get into some of the shares there may create legal issues, and it may not make it easy for you to flip. And some of the things which we'll discuss later on, like round 50 and others, may become unprofitable. So these are the few points we need to keep in mind before deciding whether they want to actually flip or not flip.
Brad, what is your view from the US law perspective? Should I flip or not flip? And also, I would like to see, think about, when they flip to US, what are the US legal considerations they need to keep in mind?
Yeah, I think it's a highly contextually dependent question and requires, as Nishith Desai said, it's an art more than a science. And I think from the U.S. side, I think it's easy to execute a flip, relatively speaking, from a corporate or a mechanical perspective. But I think the biggest thing from my perspective is that once you move to the U.S., you're subjecting yourself to the U.S. tax regime and laws, and it's very hard to, once you make that move, it's not completely irreversible, but it's a decision that the company will have to live with for the rest of its existence. So there are real consequences. It's not like a completely reversible process. I think that's the biggest thing, is understanding if you could have a crystal ball and look into the future in 5-10 years, where do you think what do you think is the likely exit path for the company? I think you need to look at that really closely and think about who your potential, who are the potential strategic acquirers for your business? Who are, where are you going to raise capital? Who are your potential investors? Are they going to, are the investors that you want to talk to on Sand Hill Road in Silicon Valley, and are they going to say, hey, we only invest in Delaware corporations? That makes it pretty easy. And I think one way that, most of my clients, make that decision is exactly in that context where you have, you're not operating in a vacuum where you're just thinking about what's going to happen, unless you're forming the company. You're doing this from initial formation. You're saying, hey, Andreessen Horowitz is going to invest. They want us to invest in a Delaware corporation. That makes it pretty easy and de-risks it in the sense that that there's capital backing up that decision. Yeah.
Correct. So yeah, there are a lot of, especially if your reason is for funding, then you have to look at what your funding agency or the VC or investor is interested in, what kind of structure they would like. So now that gives us a way into a very interesting point of, now I know the reasons for flipping. I have decided that I am right candidate for flipping. I should think about flipping. So what are the different choices of entry into US? And what are different structures, advantages, disadvantages, timeline, cost involved in that, any kind of residency requirement? So Brad, can you talk about different choices for entry and the plus and minuses of those?
Yeah, I mean, I think the Delaware corporation is the gold standard that most venture-backed companies, the vast majority, use as their form of incorporation. The pros are it's very quick to set up. It can be set up within the span of a few days. It's cheap. There's minimal taxes. There's no residency requirements. It's very easy to do. The downside is it's not a pass-through entity, so there's tax at the corporate level. So if you're gonna if your potential exit path is to sell your, operating subsidiaries, there'll be a, currently we have a 21% corporate tax, so there'll be a 21% tax on any distribution of those proceeds. So it may not be a tax efficient process. The other types of structures you could look at would be like an LLC, which is a limited liability corporation company that, it has a partnership-like tax treatment so that there's no tax at the entity level, maybe more tax efficient. Most VCs don't really like that though, so we don't really see that very often in the U.S. Those are the two main structures that we see.
Vaibhav, anything that you would like to add here?
No, I think let's move on. I can add some other thing which I want to say. I can say a little later.
Sure. So now we have decided to move into US and looked at different structure. So Priya, what kind of financial resources are needed? What kind of financial issues are there? Any kind of financial compliance aspect that you can guide them on?
Yeah, I think when Brad and Vaibhav was talking about, I think one of the things is access to other source of financing. Obviously venture capitalists are much more comfortable with a Delaware C Corp. And Brad, maybe a little bit, I also get a question more on LLC. I know you said LLC is not preferred, maybe something maybe you can go back and kind of like reiterate on why not LLC. But I think that's one,
sure.
Right? But then the same consideration comes when you look at the debt as well. So I think access to capital is through two sources. One is equity and another one is debt. Obviously, equity is through your venture capital financing, but from a debt perspective, obviously through SVB, but also through our other partners, one of the things that we can look as a part of giving out a debt is all of the things that I mentioned about as a part of the flip, where your customer base, where is the founding team based out of. But one of the other things we also look at is IP, right? Where's your holdco and where does the IP reside, if that is relevant? And I think IP is a question that's very critical to address. And I was just looking through the Q&A and there's so many questions just about IP. I think that's something that you'd look. So I think access to capital, period, gets easier when your holdco is based out of US, and especially if it's a Delaware C Corp. So I think that's where I would say Mihir.
Okay. No, this is great. Just one point I want to make to audience that if you have any questions, there are so many issues involved in this entire process of flipping and so much of uncertainty. If there are any questions, please post them under Q&A on the chat. And as the time permits, we will take them up. And if we can't, we will definitely try to come back to you offline. So please do that. So now we know the financial resources and all that, but we also need to think about, bootstrapping or moving some money from India to US. So Vaibhav, we hear about round tripping. What is round tripping and what kind of foreign exchange control issues are in flipping?
Yeah, thank you, Mihir. Now, this is possibly one of the most complex subjects which require a session by itself. And but I will try to be very brief here. Round tripping, in a very simple, meaning, is that money which is originating from India goes to US or anywhere else and comes back to India. Right? So round tripping is money which is taken from India, converted into rupees, taken from India, converted into dollars, and then dollars converted back into Indian rupee. What it means from our perspective here, right? That if you set up a company in the US, right? If Indian shareholders set up a company in the US, and then company sets up a subsidiary, then that becomes a round tripping in the eyes of Reserve Bank of India. What is important to keep in mind is that as of today, the way the interpretation is, the round tripping is restricted to setting up of a subsidiary, which means the money which comes as a capital. If money which comes as a, let's say, a business income. So for example, you set up a money in the US, and then US engages Indian company for purpose of development of IP, captive 100% captive unit kind of a thing, where they engage them for development of IP and send money back to India. That, as of today, at least what we have understood till now, is not considered to be round tripping. So round tripping is restricted to from capital perspective. Second point, what is important to keep in mind is when you do round tripping, right? Often there are two arguments. So one argument is that I send money from India to US, as long as that money does not come back to India, there is no round tripping. In other words, if money is actually sent from India to US and that money is utilized in US, a US company raises some other money, right, from non-Indian shareholders, non-Indian capital, and then use that money to put in India, then technically that is not a round tripping. However, um, uh, there is other interpretation which Reserve Bank of India likes to take, is that in their mind money is fungible, and as a result, any money which goes to US, whether that money comes back or not, if that Indian company has subsidiary in India, then they may consider to be a round tripping. Now, is there a law against round tripping? There is no law which specifically says round tripping is illegal. So where does the restriction come in? The restriction comes in primarily when you have Indian shareholder putting money in US company. That is considered to be ODI, which is overseas direct investment. And it can be either by an individual or by a company or an entity. Uh, there are regulations on both the sides, and for example, if it is company, the regulation says that your investment has to be for bona fide purposes, and the Reserve Bank of India interprets bona fide purposes to say that the money should not be used for round tripping. So this is where the issue comes on round tripping, because the Reserve Bank of India says that if your money is sent from India for purchasing of shares of a US company, and if that money was used, or that US company has an Indian subsidiary, then that was not a bona fide purchases. Now, it is not a blanket situation. There are certain exceptions. For example, if the investment is from an individual and they don't have any rights in the company, and they have made an investment less than, let's say, 5% or so, around 5% or so, then it could be considered to be portfolio investment. And if it is a portfolio investment, this restriction does not apply. However, if it is not a portfolio investment, and if it's a joint venture or a wholly owned subsidiary kind of a scenario, then this restriction apply, where money cannot, the US company cannot set up subsidiary in India. In fact, if you are an individual which has set up money, which is very common when they use LRS scheme, which is liberalized remittance scheme, to send money for purchase of shares from the US company. And this is typical when founders are actually residing in India. This is very typical when you have investors who are actually based in India, then they will use LRS as an individual, especially angels, to send money. In which case, you will end up having a situation where if it is not considered to be portfolio investment, which I just mentioned, then you can't even set up a subsidiary anywhere in the world, not just in India. So that kind of restrictions are applicable. So these are the things on exchange control side which you need to keep in mind. And on round tripping side, at least from what we understand, that Reserve Bank of India has actually come back on several situations, asking them to unwind the transaction and put penalty on it. But there have been some situation where they have considered to be bona fide. For example, you will see a lot of software industries, a lot of software companies, whether it is Mphasis, Infosys, Wipros, which will have US companies, US subsidiaries, which in turn will have Indian subsidiaries again. And that happens because when they make a global acquisition, the acquisition comes with Indian subsidiaries. So there have been situations where Reserve Bank of India has taken a view that this is bona fide, but that is up to that's something which Reserve Bank of India decides when the issue comes to them. I think this is a short point I want to talk about round tripping, and under I can talk more, but I think we will run out of time otherwise.
Sure. See, if the questions, we will come back to that, Webo, for sure.
Yeah.
Thank you. So now, finance side, one aspect is foreign exchange, because India is not a fully liberal country or open country in terms of foreign exchange. So they're controlled by RBI on foreign exchanges. Next important aspect is tax. Like they say, tax and death are the only realities of life. Harshita, can you tell us about what are the major tax issues such as, general anti-avoidance rules or place of effective management, indirect transfer tax? Can you talk about from Indian perspective, what are the tax consequences in flipping?
Sure. So I think three stages clearly, and from a tax standpoint, companies who are looking to flip must actually ensure that their taxes don't get stuck, or they don't end up paying more taxes, without getting appropriate credits for the same. And which is why tax structuring or keeping the tax reasons in mind becomes very important. Now, three buckets where I would really want to classify the Indian tax issues. One is in terms of the structuring the transaction from an India standpoint, and also to address a couple of questions on that. So I think structuring and what structure you adopt is not like a cookie cutter solution. And as Vaibhav, my co-panelist, pointed out, it's a very complex structuring and advice, which I would say in terms of dealing an analysis of your business considerations are and what are the legal considerations that probably will justify your flip. So coming back to structuring, it can either happen by way of a share sale or a slump sale, and depending on the mode that you choose, or the tax treatment would differ. For instance, in case of share sale, the pricing guidelines are going to apply, and the holding period of the shares will determine whether the transferor of the shares is going to be subject to a long-term capital gains tax or a short-term capital gains tax. Now, again, in terms of share sale, if it's a resident, the long-term capital gains tax is going to be 20% versus a short-term, which is 30%. And when it's a non-resident, we are talking about it. The long-term capital gains tax is 10% versus a 40% for short-term. Now, moving on to the other commonly used situation that we've seen, in which cases businesses are transferred from an existing Indian company to a new Indian company, and then there's a flip which takes place. Now, transfer tax in this case will be in the hands of the seller entity, depending on the holding period of the business undertaking and the cost of acquisition of the business undertaking. But an important point here is to consider that after the flipping, there are certain challenges in terms of running and managing the structures, and which is where tax concepts like POEM, which is place of effective management, and anti-avoidance come into play. So one of the biggest risks that we see in terms of structures today is in terms of the place of effective management. Now, very, very important to consider here is, because let's say if there's an Indian promoter who's not going to move his base abroad and he's going to remain in India, with all the key decisions with respect to the entities being taken from India, it is likely that the tax authorities in India are going to view this as a case where the place of effective management will be treated as India, and your global income, in terms of the overseas entity, will also be taxed in India. Now, the criteria for determining POEM is a little subjective here, and there are, while there are thresholds specified in to determine the tax residency, it depends on case to case scenario and how we look at it and how we structure the transactions accordingly. Now, second scenario in which the structures run a POEM risk, and where we have seen is when your team or the IP essentially is based in India and a large part of operations are happening out of India, and the foreign entity may just be the holding entity, or at best doing some marketing functions for the Indian entity. Now, while you may be booking revenues at the offshore level, a lot of that revenue may need to come to India under an appropriate transfer pricing study, which is basically required to establish the relationship between the US entity and the Indian entity. There again, there is a risk that the companies run in terms of being of the tax authorities classifying that the POEM is in India. Now, which is why the emphasis on structuring a flip is not only to ensure that the Indian entity becomes the subsidiary of the US entity, but it goes far beyond to analyze how your business objectives will be achieved. What is the functional analysis of the business? Who are the people who will be helping you out at the overseas level, and what are the functions which are being going to be carried out at the overseas entity level? Now, the thirdly, and as Mihir pointed out, in terms of anti-avoidance, which essentially comes into play at different levels. But before we get into when does it come into play, let's discuss what is anti-avoidance. Since a large part of the startups we expect is startups, and large part of the audience is startups and investors, it's good for the audience to know that what tax avoidance means and how tax authorities in India look at it. Indian tax laws, essentially came out with a rule in 2017 where they specified that once a transaction is done and the main purpose of the transaction appears to be to avoid tax, then the tax authorities can do a couple of things around it. One, they can either ignore the transaction. Two, they can tax the entire transaction. Three, they can apply different taxes in the hands of different people. Different treatment of taxes. Now, a thing to bear in mind here is that GAR once invoked, or general anti-avoidance rules once invoked, can also deny treaty benefits, and which is why it's important to keep them in mind at every step of your structuring. So and to give an example to help the audience around here, let's say the promoter acquires shares in the foreign entity at a fairly nominal cost, or the promoter's shareholding in the Indian entity is diluted significantly. What happens is that the holding company, what we've seen in structures is that the holding company, which usually starts with nominal capital, investment from India is also pretty nominal. And ultimately, when the Indian entity is held and the structure is up and running, the value suddenly shoots up of the US entity. And this is where the tax authorities view it as a swap of shares. And a swap of shares becomes a taxable event in India. So as a concept, and as a, going back to the basics of the tax laws in India, tax authorities are generally averse to give something in India in exchange for something that you're getting abroad. So to keep that in mind. So, another example could be where revenues are booked at the offshore level, where most of the business operations are in India. The tax authorities can again argue here that the revenues are all actually attributable to India and hence liable to be taxed in India. And I think the third one, sorry, Mihir bhai, just
Go
before
ahead. Go ahead, Harshita.
just before I step on, it just relates to some of these questions on IP, which have come from the audience. So IP being the most valuable asset to startups, in fact, companies, particularly startups, the valuation of IP becomes very subjective, and it may have a certain value in the minds of the promoters, something else in the minds of the investors, and completely, different in the minds of the tax authorities. So transfer of IP from your Indian entity to the overseas holdco, can invoke anti-avoidance again here, because it is done at a time, and it's usually done at a time when the value is low. But once the tax authorities viewed the transfer in a way that the usage of IP or the revenues arising from the usage of IP is going to be actually captured in the foreign entity. So again, transfer of IP and documenting it with appropriate transfer pricing study becomes another important facet, in terms of analyzing whether anti-avoidance rules will really apply.
That's right,
Just to
Harshita.
add,
Vaibhav, anything?
no, I just want to inform the audience here that we are having one more session. We are having another session on June 3rd at same time, where we are taking only tax considerations on India-US structures. So some of these questions will also be addressed in detail during that particular session. So just to keep tell everyone.
Mihir, I was just going to add on to
Priya,
one
go
thing
ahead.
what Harshita was saying. Harshita, are you back on? I think one of the other questions is, as Harshita was talking about, that comes up is because of so much of complexity and nuances related to when like the IP transfer specifically, and our previous guide, like when we were talking earlier in the call, we were saying, think about it early, don't wait until it's too late. But
That's
now
right.
it seems like, what is the right time? Because I think it's a lot more complex than what it seems, right? Like if you have to make it simple, is it better to do it early on the flips, or is it better? What is the right time? I think that's the critical question, especially with the IP in mind, right?
That's right. So, if I may take a jibe at that question quickly for the benefit of the larger audience. So, I think generally what we've seen is that the more you take time in terms of getting your investments or external investors into the Indian entity and then decide to flip, the more complex it gets, in terms of flipping. So, the early on you flip, the better it is, and lesser the complexities involved. Though there are legal and regulatory challenges in India, and again the tax challenges remain as is. So, you'll have to bear all that in mind and create a structure for yourself. But the early on you do, the better it is.
So I actually I'll add to it. I was discussing during earlier in the session that early you do it may be possible. If you do at a later stage, the cost may be too high to do it. To make it, sometimes we have seen when companies came to us for flipping, they were at such a stage that well, there were business benefits for them to flip, The cost of flipping was very high, the risk of flipping was very high, and in some cases it was not possible for them to flip because, and I just give an example of Indian investor, same way there was one situation I remember where um, they had an investment from VC, which is an AIF in India. And AIF in India, which is a venture capital, registered venture capital with SEBI, can invest up to 25% outside India. Once they exhaust the 25% cap, they can't then invest outside India. And in this case, I know somebody came and say, we want to flip and, we want this company to come, but they had exhausted the 25%, which means they could not have flipped. They could not have got that VC as an investment. So what I was trying to say earlier and what I will say now is, earlier the better. Otherwise, the cost, and sometimes you may not be in a position to flip in because of legal reasons, even though you have a business case.
No, very good point, Vaibhav, because when to flip is also very important, right? At what point you should think about flipping and consequences at that point. Let me come back to Brad and say, what are the issues in tax and other aspects from US law perspective? And think about also, Brad, if you can just talk about, as Vaibhav brought out, at what stage, early stage company versus later stage company, what are the issues that are differ from those two different stages? So Brad, anything from US perspective that you can add?
Yeah, sure. I think IP is also an important topic from the U.S. legal perspective. Also, obviously, also from a business perspective, in that some certain investors may say, "Hey, we want the IP to be situated in the U.S. just because we have comfort in in knowing that there's IP in the U.S." Whether that actually means anything, I don't know. But and so that's one thing, and that may have a tax hit. If for an early stage company, that's easy because you can just set up the company and have the IP initially seated, in the U.S. The other thing is which interplays with the choice of structure is if you're going to use an LLC or an entity that's a pass through for U.S. tax perspective, you can't really have any assets in that entity, or the investor's preference may not be that there's no assets there, because then they could be hit with different taxes if they're investing directly into that through a partnership or a fund vehicle. So there's additional complexity associated with that. For later stage companies, another issue that I've encountered is U.S. securities law issues, where we had a company that had flipped initially from India to Singapore. And then, had been in Singapore, had a Singapore holdco for 5 years or so, and then decided they wanted to move to the U.S., during which time they had amassed over 200 shareholders, some of which were former employees. And so we had to actually conduct a securities law hearing in the U.S. that, we required the CEO to fly to L.A. with me and, spend the morning in a dingy, DMV-like office in Los Angeles to talk to someone about approving this flip. So there's all these unanticipated things where if you have a lot of shareholders, you've raised a lot of capital that you'll have to take into account. And we also had to do a merger in Singapore, and we had to align those those timelines together, and it ended up the whole process took us over a year to move that late stage company to the U.S. So if you're coming in through YC, setting it up, then you're in a much better shape. You can just move quickly and execute.
Because I think
quickly.
Exactly, the cost aspect, complexity aspect increases exponentially as you get into later stage, right? So Vaibhav suggested try to do it as early as possible if you're really looking into it, or at least think about flipping as early as possible, because as you move to the later stage, as you kick the can down the road, the can gets bigger and bigger, and it's going to come back and hurt your feet. So always keep that in mind. Another issue that I want to bring up is, a lot of these companies, because they're startups, especially early stage, one way to attract talent is through ESOP. So Brad, you want to talk about ESOP situation in the flipping and from the US perspective, and then we'll come back to Harshita and look at it from the India perspective.
Sure. Yeah, I think from a U.S. perspective, if the company is domiciled in India and already has an ESOP set up there, you would, ideally you would somehow be able to migrate all that ESOP plan up to the holdco level, the new holdco level, so that you have, a consolidated shareholding, at one level rather than at multiple levels. I know sometimes you can't avoid that, but that's one thing that investors often will want to see. So that's something to take into account on both sides. But I think from the U.S. perspective, it's pretty easy. I think I think the U.S. is much more restrictive in terms of, from a tax perspective for tax residents of the U.S. To comply with 409A, which requires options to be priced at a fair market value at the time of grant, which still won't apply to companies with operations solely in India. So I think really most of the ESOP issues are, again, assuming you're able to migrate, your existing ESOP to the new U.S. holdco level are all driven by, again, India and foreign exchange and tax considerations for the most part. And we can, ESOPs in the U.S. are basically, standardized, very highly standardized, at least for venture-backed companies. You see a lot more variation in Singapore and India and other places. I think we can just, generate one very quickly for a U.S. company. It's a pretty easy process.
Sure, good. Harshita, from Indian law perspective on the ESOP side.
So I think just a quick liner around that. So it's possible for the foreign entities, the overseas holdco, which have been set up to issue ESOPs to the employees who are there in India, and vice versa. So it's also possible that the Indian companies can issue ESOPs, to the employees who are of the foreign entity. But I think the former comes more handy in cases of flips, because the holdco will essentially be carrying the value of the entire structure. In which case, it will be beneficial to take shares of the holdco, grant the shares, the options of the holdco to the employees in India, which is possible under Indian laws. So just a bit there.
Sure. See, we have seen with this coronavirus and COVID situation, we have seen U.S. government and Federal Reserve have provided stimulus, trillions of dollars of stimulus. Mm-hmm. And one of the very flagship program is Paycheck Protection Program. Brett, can you tell us a little bit about what are the benefits or any kind of possibilities for a flip US company from this stimulus money?
Yeah, the Paycheck Protection Program was put in place to incentivize companies to keep their U.S. employees employed and to continue paying them during at least the next 2.5 months. It's the loans are for up to 2.5 months of paycheck payroll expenses. You need to have a U.S. entity to be eligible, but even with companies that I work with that are headquartered in the U.S., have all their operations in the U.S., it's been a very complex and difficult process to determine, because you have to determine whether or not there's necessity. You actually need this to continue operating, which is if you're backed by a Sand Hill Road venture capital fund, that the question initially was, everyone initially thought, oh, it's great, let's all just charge in, and then over time we saw people VCs changing their minds, companies, clients of mine that have given the money back. There's also the requirement that you be a U.S. small business, which means you have employees in the U.S. So if I think if you just were flipping for purposes of access to the PPP, but you're only operating in India, then there wouldn't really be much benefit from that perspective at all. But there are other tax benefits that from the entity level that you may be able to avail yourself of, but I don't think that should be obviously a driving factor in flip analysis.
Sure, absolutely. Now this program is administered through bank. Priya, anything you would like to add into this?
Sorry, it was on mute. No Brad said it right. I mean, absolutely. I think it's just a matter of, we've seen it all. I've been a part of that process. Typing it all night, every night, pretty much entire bank was on
everybody's rushing, right?
Everybody was, but we saw pretty much all of the faces, right? Everybody rushing to apply, then everybody rushing to question themselves, and everybody now a lot of them pulling back. So I think do you really need it? I think the question is, It is for the businesses that truly need it. If you've raised money and if you have other sources of capital that you can tap into, then this is not for you, right? Like, I think just common sense. I think that's just the logic that the stimulus is for. But flip, I mean, we would look for, at least when we were looking for, I think the basic consideration, as Brad was talking about, you have employees in US. The goal of it is to keep the employment there, right? And to add on more. So I think that's the only thing I would add on. Just be conscious on why you're taking what you're taking.
Very good point, because not only just legally possible, but also ethical and moral aspect of it to see whether you really need it. That's also very important, because also that will set the stone that how your culture will get developed in your own firm. Now, before I flip, I want to know whether I can unflip, right? If I need to at some point of time, right? Why should I flip before I know I can unflip or not? So, Brad, can you tell us about, how company can unflip and what are the issues in unflipping, which means moving back to India or moving to some other jurisdiction from US legal perspective?
Yeah. I think I do see this pretty frequently actually, where companies that go through these accelerator programs like Y Combinator, or said, hey, you have to set up a Delaware Corp, and they're like, great, we're so happy to be accepted to this program. This is great. And then a year or two later, after they've raised their safe round on demo day, get a Series A term sheet from a fund based in Southeast Asia or wherever, and they say, well, we can only invest in a Singapore company. And then the client comes back and say, well, how do I do that? Can I just do a share exchange? That's what we did. That's what we did for YC. We just exchanged shares and then we called it a day. And then unfortunately, the US tax system is, global in nature. And so there really isn't a way, and Nishith was talking about the inversions, and there's these anti-inversion rules that basically penalize you or disincentivize you from doing a flip out of the U.S. So I think it's possible to set up a new holding company, such as in the Cayman Islands, Singapore, wherever, after you have a Delaware company, but it won't be a perfect solution. You have to, at least from a U.S. tax perspective, freeze the value that the company had accrued or accumulated up until the point when you unflip in this new holdco, so that there'll be two levels of tax or tax in the U.S. on that entity in an exit kind of transaction. So, with some companies, we've done what is called a freeze, where you have to work with, there's different ways of doing it, but you need to work with, tax advisors, local, on the, Big Four side or whatever, and local advisors in India, and the U.S. It's very complicated and costly to do, but you can basically do that where the old holdco becomes a shareholder of the new holdco, and somewhat preserves and most of it's driven by for tax reasons or regulatory reasons, but yeah, it can be done. I guess I would just say, it's complicated, it's expensive. You can do it. Some late stage companies, as has been alluded to, have looked at this and have decided it's not worth the effort or it's too expensive, but it can be done. Usually, from what from my experience, I think if you're like at the Series A, Series B stage, that's kind of pushing the valuation or growth level, to anything beyond that, it'll be pretty complicated.
I see. Vaibhav, anything from the Indian law perspective about unflipping or inversion?
So unflipping is easier than flipping. So that's a good news. Having said it, what I think we need to keep in mind, specifically because the flip we are talking about is more likely not than not have shareholders who are based in India. And what we need to keep in mind is that the flipping or unflipping will not be tax neutral, which means there will be tax on each level. So, you need to be careful, because not only there will be tax impact or tax considerations which may have when you flip to US or some other country, but when you flip back, whether from US to Singapore or to India, there will be tax consideration at that level. Also, there may be other exchange control consideration, because the money actually has gone from India, and to that extent, you need to keep that in mind also. But generally, what we see is that that's a lesser of a problem.
Okay, Priya, Harshita, anything from your perspective, anything that we want to consider in here from a financial institution side aspect?
Nothing from my side.
No, none from my side as well, Mihir.
Okay, okay. Are there any other issues that I would like, anything that we have missed, any of the panelists would like to bring up and talk about it? We have gone through many different issues, but it's such a complex process that anything
I
that
think
you've seen.
I would want to add just one thing, as it was very evident, right? There are a lot of legal issues, tax issues, both in India and in the US. On top of it, there are a lot of business considerations which you need to keep in mind before you flip, why you flip. Also, I think what I would want to say is that what kind of it tells me is that flipping is not for everyone. And flipping is something where you need to really apply business sound case and what is the situation in your company before you decide to flip, right? And so don't say that, oh, my colleague or my other partner or other startup has flipped to US, so I should also flip to the US, right? It doesn't make sense. There is no herd mentality which works in this particular situation. That is what I would want to say. So don't flip for the sake of flipping, or don't flip because somebody tells you to flip. Think on a long-term basis and see where it makes most business sense. Secondly, what is your personal situation, especially if you are a promoter or a founder and you are not moving to the US, right? Then you'll be sitting in India and controlling that. That means there are a lot of tax issues and exchange control issue which we just identified works on you, which may have a very different long-term implication, which may affect your exit. So you need to be very careful when you come to a decision to flip or not to flip. I think that is what I would wanted to add. It's very individual decision and not a herd mentality.
I think just to add to what Vaibhav said in terms of the decision to flip, I think one more point to keep in mind, and this is basis our experience of dealing with various structures, is that one structure may work for one startup, but that necessarily may not work for every startup. So just because one of the entities has taken a particular structure and implemented it to flip does not mean that it will work in your scenario. So structuring becomes a very important part, and you'll have to see it on basis your facts and circumstances. You'll have to decide what route to adopt. Just to answer that question which has come up on structuring from a lot of attendees.
Mihir, I would also add on to say, I mean, there's been so many questions, so they can always feel free to reach out to any one of us if they need more. I just wanted to throw it out there as well.
No, I will definitely bring that up.
So Mihir, I needed to add to
something, right?
Yes, I want to add to what Harshita said, right? So it is not just what worked for one will not work for somebody else. Also, what worked 2 years ago may not work now. So that also you need to keep in mind. A lot of time people come and tell me, 2 years ago we did this. Why can't we do it now? Right? You can't do it now. That was a very different scenario, different set of laws, different set of circumstances. So that's one reason why we are not gone into structure details here, because it may actually confuse people and make it a little worse for them rather than making it better. But if you want to know about what are the options or structures which can use, you can always do on one basis based on the situation, circumstances which apply to you and your company.
Absolutely, absolutely. Brad, anything you want to?
Yes. Thank you
ahead.
for having me. If anyone has any questions on the U.S. side, feel free to reach out to me directly.
Absolutely. Just one quick last point. There are so many questions, and that means this is very interesting topic for many people. One area that I want to just quick 1 minute take on from the investor or shareholder perspective. Albert Da Costa has asked this question that, can we talk about from the investor perspective? We have talked about the company perspective. What about the investors or shareholders in the company perspective? Anything quick, one.
Okay, I can take from investor perspective. 2 points, right? What we have seen is that investors, at least especially as Priya mentioned, US VCs, for example, prefer to invest in a US company as opposed to some other company. Some combinators, Y Combinator, some of those accelerators also prefer to do that. And there are several reasons. Some are business reasons, but also from legal perspective, what we have seen is that Indian corporate law is a lot more restrictive, let's say, than US corporate law. So it is easy to get certain rights and enforce certain rights if it's a US company versus Indian company, and which is another reason why they prefer to invest in the US company. But on the other hand, I think Harshita mentioned that there's an indirect transfer tax, right? So if they invest in US company where the main operation or the particular value is coming from India, then that becomes an issue from that perspective, right? So often you need to look at how do you marry the benefits versus the risk or the cost which you have, right? Personally, I have seen is that US VCs will prefer investing in the US company, but if the business idea is good, or if the primary market is Indian market, they will invest in an Indian company. Right? That's the part. I think Nishith, I
No,
wanted
this
to
is great.
speak.
This is a very complex topic. Perhaps we would need 2 sessions of this to cover all these different issues. We are unfortunately out of time. There are a lot of questions. We'll try to answer them offline. And you can always reach out to Priya, Brad, Harshita, Vaibhav for any one-on-one situation that you may be facing. What I would like to do is just have last 30 seconds with Mr. Nishith Desai, our founder again, do the closing remark. Nishibhai, over to you.
Yeah, thank you so much. Since I have 30 seconds, two things. Number one, that it for the investors in India, when you flip, there could be some tax issues. But once you have flipped to the US corp and you are holding shares of a US corp now, then when you sell the US company shares, there would be no tax. Okay. But other thing is that you shouldn't go in for what is called LLP to start with. You might want to have a C corp first, and then underneath that you can have LLP and stuff like that. So there are further structuring issues as well. One of the non-tax issues that we have seen is many a times the US customers want to sign contract with the US company. I think that is where the value gets built up in the US company, and there are certain ways to avoid what you call indirect transfer tax, because the value of the US company will be significantly more, and it doesn't derive a certain percentage value from the Indian assets. So there are interesting things, and so one is that there is no cap gains on the sale of US company shares in the hands of the Indian shareholders. Number two, tax rates in the US have also come down. So I think that's the other thing. And third thing is that often it is more from a business perspective that you might want to flip. And there is, has already been mentioned, number of different issues. We'll be taking up those, I think in June 3rd, you say? When are we having the next session?
Correct. Yes.
Yes,
Yes.
I think
June
some of the
3rd.
questions which have come, I think we'll try to address it
Same time.
as well. And we'll have a longer time for the session, so people are not deprived of.
Yeah, that is primarily on tax.
Oh,
Yeah,
that will
30
be on
seconds.
text.
I couldn't talk too much. In 30 seconds. So
So,
hopefully, thank
sorry.
you.
Thank you so much. Thank you everyone for joining. I also thank my co-panelists for giving such a brief and very simple answers to complex problems.